Yes.
So, my Lord, I was going to move on to what the ramifications were in practice of having made this error of treating this as one claim. But just before I do, just to perhaps flag up how the judge dealt with this error in her judgment, which is MS page 201, and it's tab 8, page 28, paragraph 19. Said on behalf of travellers during the hearing of this application that although there were many claims, they were treated as one because they raised common issues. That is not correct. Each claimant had a separate cause of action, and from the outset it was transformed case that each claimant would have to prove the particular implants supplied to her were defective. That was pleaded in the defences, repeated in notes of conferences, repeated in court before me on a number of occasions. And that has been travellers' position throughout in the Court of Appeal, referring to it as a claim with insured and uninsured elements, and indeed in this court referring to it as a common defence, and it being conceptually no different from a single claim. And as I said before lunch, that appears to derive from a confusion between the way in which common issues were described for case management purposes in a looser sense, whereas in the New Zealand products sense, it's restricted to indivisible costs. So, how then should they have dealt with matters? Well, so far as the cohort of insured claims are concerned, that will be claims that were insured or which might be insured. In defending those, we have no issue with the way in which travellers went about things, setting up a joint retainer of solicitors, ensuring that the insured participates in joint decision-making. Perhaps worth mentioning that even in respect of the insured cases, there was still an uninsured element, because even in those cases, there was no cover for the cost of replacement of implants. The reference to that is policy wording, paragraph 7, page 365, MS, page 365. So that even the insured cases had an uninsured element. So there would have needed to have been joint decision-making, and we take no issue with the Court of Appeal guidelines that would have applied in that situation. And we entirely accept that the jurisdiction would only arise if there has been a sufficient overstepping of the mark to enable it to be just to make the order. And of course, the terms and conditions of the policy would apply in dealing with those cases, and in particular clause 6G, the right to veto an admission, not just admissions, but also offers. Clause 6G extends to admissions or offers, and that of course would apply as one would expect it to apply in a claim that may have mixed insured and uninsured elements. They would need to take care not to overstep the mark. And there was a note handed up by travellers to the judge, it's referred to again before this court, setting out a whole list of examples over several pages of joint decision-making. And we have no issue with that so far as the insured cases are concerned. And when it comes to disclosing insurance information, there would need to be a collaborative approach. Again, we make no criticism of that. And as I said before lunch, of course, the obligation is to pay the defence costs on all issues. When it comes to the uninsured cases, then in those cases, we say the appropriate way to proceed is for no reason why BLM cannot act for Transform in those cases the same way as they did in the insured cases, but it would need to be under a separate private retainer funded by Transform. Of course, we know that a private retainer was in fact set up, but it seems to have been underutilised. The only evidence we have is a bill of £153. Not surprising, because of course we know that Travellers was in fact funding and defending under the joint retainer all of the 4 sample cases, and that of course is where the work was being done. So the reality is that the private retainer was sort of sitting on the shelf, but it's that retainer, it was under that retainer that BLM should have defended the 2 uninsured sample cases. And that would mean that when it came to the true generic issue, the Russian roulette point, the reality is that that could have been investigated, paid for, dealt with by reference to the two insured cases, and when it came to the two uninsured cases, there was no need for anything further to be done. You just take the incidental benefit, but it would be under the private retainer that the work would be done on other issues. Now, turning then from there to the particular matters, sorry, just actually to one point, actually, just in terms of the way travellers went about things, there hasn't been, in all of the authorities, a single example given by my learned friend of a single case in which an insurer has in fact gone about defending multi-claimant litigation in the way that they did. There's no precedent for that. No practical example has been given where you've got multiple claimants against a single defendant, where some claims may be insured and some not, and yet the insurer has undertaken joint control of the defence of the sample cases. And that would be surprising if my learned friend's point had merit. But one sees this, of course. The courts come before the courts. Group litigation doesn't always involve pure generic issues. One thinks of historic abuse litigation, for example, where you have multiple claimants suing a defendant over different periods of time. One might have an insurer for one period of time, a separate insurer for another, and perhaps a period of self-insured period. There's no reason at all why you could have the same solicitor on the record in defending each case, or you could have different defendants, different solicitors, one instructed by one insurer to defend one cohort and another to defend a second. That may be for commercial reasons or for conflict of interest reasons. There's nothing surprising about that. The reason why learned friend travellers have struggled with that is because they have seen this as a trial of a generic issue when it wasn't. Of course, in that sense, you can only have one firm on the record. The only practical example that is referred to, albeit in a footnote in a textbook, but we've got the authority, is Wyeth and Signer, which arose out of the benzodiazepine litigation. It's perhaps worth just looking at how that was dealt with, and that is in the other authorities bundle at tab 40. Sorry, that's MS page 1736. It's other authorities bundle, tab 40. And on the internal page numbering, page 454 of the report. This was, so group litigation, lots of claimants suing a single defendant arising out of allegedly defective benzodiazepine product liability group action. And there was then satellite litigation between the defendant and number of insurers as to who was going to pay what in relation to which bits of the claim. Much of this law report is concerned with other matters. But there's one particular paragraph I wanted to take to. It was paragraph 53, under the home policy. The only issue on the home policy that now remains relates to apportionment. As already indicated, Signer concede, that's the insurers concede, that Wyeth, the defendant, are entitled to recover costs which are reasonably related to the defence of a claim alleging that an injury, illness or disease occurred during the period of the home policies. Wyeth concede, in relation to these policies, that if Signer, the insurer, can demonstrate that the costs have been incurred in relation to a claim which is not covered by the home policies, Signer will not be liable for those costs. Unsurprising, and in practice, that is the correct way of dealing with matters. So when it came to the two uninsured sample cases, those were matters that should have been defended and funded by Transform alone. And so turning then to the particular matters that the judge relied upon, so the admissions, Travellers has maintained the assertion throughout that it was entitled to veto an admission under clause 6G in all cases. Learned Friend this morning seeks to slightly a little bit coy about that, in sort of saying, well, we wanted to be consulted about it. But their case below was that 6G applied, and that was the evidence of Mr. Keating below. The reference is MS 315. His view was that you couldn't make an admission in uninsured cases without admitting in insured cases as well, and on any view the proposal of an admission required travellers' consent. It's their case below. And if this had indeed been a single claim, of course that would be right. But that's not correct. If it had been a trial of a single issue and the question had been from us, will you please admit that this product is defective, then of course it would be forensically extremely difficult to admit that point in some cases without it having an impact on others. But that wasn't what was being requested. What was being requested was for an admission of liability in respect of particular uninsured cases. This was at a time after it had become clear which cases were insured and which were not, and after it had become clear that Transform was heading towards liquidation. I think it may even already have been in liquidation by this point. And so there's no reason, in my submission, conceptually, why Transform, represented under a private retainer by BLM, could not have said to the claimants, well, and indeed to the judge, for commercial reasons, we're uninsured, we haven't got any money, we are making an admission purely for commercial reasons that we are liable to the claimants in this particular group of cases. And that would not have caused any, certainly wouldn't have caused any legal difficulty to Transform and Travellers in defending the insured cases. And so far as the forensic fallout is concerned, when one sees this as an admission of individual cases on their individual facts, in circumstances where the defendant has said each case must be determined on its own merits, then the forensic fallout becomes, in my submission, marginal, given that it would be put in those terms. But if Travellers had had a concern that it might in some way prejudice the judge in determining the defence, although that would be surprising. Lots of different defendants in this litigation. Some were settling, at least one made an open admission of liability, albeit other defendants. So, but if that was a concern, then the admission could have been made confidentially. How could that have worked? This would have been confidential to the judge, not confidential to Travellers. There's no reason in principle, if that was a concern, why an application couldn't have been made for the court to approve a consent order, saying, well, Judge, we're aware that other cases are being disposed of in different ways, different defendants. Here we have a cohort against Transform, insolvent with no insurance. It's agreed that the cases on this schedule shall be removed from the GLO register and stayed and dealt with in due course. The parties have come to a compromise.
Same solicitors were acting for all the claimants. So
yes.
How could it have been confidential to the judge without being disclosed to them? You tell the judge, you ask the judge to approve the settlement by documents which you don't disclose to other parties of the settlement. Is that the...
Oh, no, they would be disclosed to the parties to the settlement, the claimants and the defendant. But if the concern on Travellers' part had been, well, if there's an admission in that cohort of uninsured cases, that might in some way prejudice the judge in determining the merits of our cases, which would be an unfounded concern in my submission. But if that was a concern, then the judge needn't necessarily be informed that an admission had been made.
So how would they explain, or wouldn't they explain, their selection of defendants with whom to settle?
Well, by this point, of course, it was clear which cases were insured and which were not. And so the judge can be told, well, here is a group of cases. Transform would be saying, we haven't got the funds to defend these cases, we haven't got insurance, we've come to terms with the claimants.
We're happy to admit liability because they'll never get a bean out of us anyway. Is that what he should have said?
Yeah, well, that would be non-confidential, but yes, if the judge was told of the admission, and of course the reason for doing that is because it stops the clock in terms of the claimants incurring ongoing several common cost shares. The only way you can stop the clock in terms of each claimant's ongoing accrual of costs, and this isn't, of course, just solicitors' profit costs, it's also disbursements and other costs, expert evidence and so on. And the only way you can do that is to discontinue, to settle, or to have an admission of liability.
Do you go so far as to say that Travellers could not reasonably have taken any other course than that one?
Travellers, my lord, yes, I do say that Travellers had no business to play any part in Transform's decision-making as to whether to make an admission of liability in uninsured cases.
But is it the position that if travellers took the view that making that admission would prejudice their case in relation to the 197 insured cases, if they took that view, do you say that that was a view that no reasonable insurer in their case could have taken as a matter of forensic judgment?
My Lord, I do say that. I said before it would have been unfounded for them to have that concern, and I stand by that.
I think you've got to go that
yes,
far.
Yes, the reason for that, of course, is that it was well known to the court that there were a range of defendants, some of them of varying means. As I say, some were settling, one admitted liability. There were other defendants who had, because the Transform was taking the running in defending the sample cases, directions were made permitting other defendants, if they wanted to participate in the trial and make submissions. As it happens, wasn't taken up. But each had the opportunity to participate. But ultimately, it was for each case to take its own course, each defendant to take their own course. So just as one defendant, separately represented, undefended, might have admitted liability, there would be nothing particularly surprising in Transform, also unfunded, without insurance and without funds to go the distance, also making an admission for commercial reasons. And in my submission, that would not have caused any prejudice to travellers in defending the insured cases. It might be rather different. My learned friend said, what if it was the other way around? What if it was Transform admitting liability? Well, if it was travellers admitting liability, if travellers had come to court and said in open terms, we're admitting liability not for commercial reasons, but because we recognise that the evidence is overwhelming on the Russian roulette point, we have no defence, it's hopeless, and so on, well, one can see why that might cause some concern to travellers, to Transform rather, in defending the other cohort. But a pure admission made for commercial reasons, in my submission, would have been, on any view, well understood by this judge on its merits as the way to stop the clock on the ongoing accumulation of costs, and would not prejudice her in dealing with the issues arising in the insured cases. But as I say, even if that had been a concern, the matter could have been dealt with by the admission being confidential. The judge could simply be told the parties have agreed terms upon which the claims can be removed from the register. Learned friend says, well, of course, if it had been two claims in a county court somewhere, of course that could have been done. The position here is no different, because this is not an admission of the generic issue in the litigation. It's an admission of liability in particular individual claims. And if necessary, there was some discussion about this in court, the judge could be reminded, if she needed reminding, that it was the defendant's case that the Russian roulette argument had no merit and that each claimant needed to prove liability on her own individual facts. That might be another way of packaging it. But if to return to Lord Milord's point about travellers taking a view about this, if what of course could have happened is that if you'd had these separate retainers operating as they should have done, so private retainer to defend the uninsured, joint retainer for the insured, the solicitor advising Transform under the private retainer would have needed to ask himself the question, if an admission of liability is made, is that something that might give rise to a potential conflict? In my submission, the answer to that question would have been no, for the reasons I've indicated. But if a potential conflict had arisen, conflict of interest between Transform defending one group, Transform and travellers defending another, then the way to deal with that is for Transform to take independent legal advice on that question.
You say that the settlement between Transform and uninsured claimants could have been kept confidential from the judge, but if it had to be communicated through solicitors also acting for the insured defendants, how could they have been restrained from telling the judge about it?
Well, the issue of confidentiality was a suggestion in relation to the admission, the bare fact of an admission, rather than the fact of a settlement.
Well, why is not that? Well, okay, let me ask the same question in relation to an admission, because it's the same firm of solicitors acting for all of them. So the solicitors come to know that an admission is being made to the uninsured claimants. They can't keep that from their insured clients. No. Insured clients can't be restrained from telling the judge. So how can it be kept confidential from the judge?
Well, the way in which the insured cases were settled was with a Tomlin order with a confidential schedule. So that would be a good example where the judge was not informed of the terms of settlement. They were set out in a confidential schedule with an open Tomlin order. That's one way in which it could have been done. It could have been agreed on confidential terms. But I don't particularly advance that submission. There's no need for confidentiality in relation to settlement, particularly if it's settlement with a defendant who's got no insurance and no money. There's no need to be coy about it. Perfectly obvious why cases would be settling. The suggestion of a confidential admission was more in desperation than anything else, because there simply wasn't an admission being made, and Transform was saying, our hands are tied, we need travellers' consent. The judge was right to say, as she did at paragraph 30, at MS 206, otherwise page 33, that it was not for travellers to consent to an admission of liability in the uninsured claims. Let's bring the page up. That's sort of about 5 or 6 lines down from the top of the page. The fact that it insured 197 different claims did not give it the right to influence the conduct of the uninsured claims. She was, in my submission, entirely right to say so. And that really goes to the heart of the matter. And at worst, it would mean that the lawyers, if there really was some issue there, would need to consider whether there was a conflict and react appropriately. And then, as she found on the facts in the same paragraph, travellers refused consent to an admission of liability. Learned Friend takes issue with that case. He says, well, Mr. Keating says that that's not correct. Well, the judge had, there's about 1,000 pages of evidence on the memory stick before this court that the appellants seek to put in, and that's only a selection of what she had before her. She had copious emails, correspondence, and materials to deal with in making the findings that she did. But actually, the distinction between the parties on this point is actually pretty marginal. As I understand it, the appellants say, well, we did say we asserted the right to have a veto, and we did say that Transform would need our consent to an admission, and they did ask us for our consent to an admission, and we did say that if you admit liability, it'll be a breach of the policy, but we didn't actually refuse consent to it. Well, that's a pretty marginal distinction. The reality is that an admission would not have been a breach of the policy. An admission in an insured case might have been, but in an uninsured cases, there would have been no contractual issue at all. And again, it's an illustration of the mistake of thinking of this as an insured case with mixed elements, and therefore the terms and conditions apply. They don't apply. I've learned for an attempt to retreat from that this morning by saying, oh, well, we at least would have wanted the right to be consulted. Well, either the terms do apply or they don't. In my submission, they don't. But would have done if this had been a trial of an issue and one's dealing with admission of that issue. That would be different. That's not this case. So that was the admissions. And then so far as settlement offers is concerned, again, the difficulty with the appellants having categorised this as a single claim leads them to take an inconsistent approach. They say with admissions, we did have the right to veto under clause 6G, but offers, no, we only wanted to be consulted, we didn't have the right. Well, clause 6G actually applies to admissions and offers. And the reality is that it didn't apply. The facts found by the judge were found, again, in the light of a considerable volume of evidence detailing a pattern of behaviour and a pattern of correspondence involving Transform and Travellers and BLM throughout the litigation within the joint retainer. The facts that she found are only a summary, a short summary of, as it were, some of the highlights. But as she found, there was a need for travellers to consent to drop hands offers. And yes, as Malone Friend said, it's right that travellers had in July 2014 at one point agreed to a drop hands offer being made in uninsured cases. But that was in the context of the run-up to a mediation. And as the judge found, that mediation was unsuccessful. And the reason for it being unsuccessful was because of a lack of cooperation by Cloverleaf, the Part 20 defendant. Cloverleaf was the UK company that supplied the implants to Transform, which was also a shell company, and it had insurance from Amlin. It's agreed by the appellant that from the outset, it was always assumed by them that the Amlin cover would not cover worried well cases. And by the summer of 2014, travellers had become aware of the fact that in relation to rupture cases, the scope of the Amlin cover was a bit wider than travellers cover in terms of temporal scope. And there were some 67 cases, I think, that would potentially fall within scope of Amlin cover, but not cloverleaf. The relevance of this, of course, is that the judge found that, well, the mediation was essentially adjourned, put off. Cloverleaf aren't engaging, so we'll put it off. And the approach from travellers and Transform throughout, as the judge found, was that they were looking at settlement in terms of not wanting to prejudice their potential right of recovery from cloverleaf, indirectly from Amlin, in respect of cases that might be covered. They didn't want to do anything that might prejudice that. And the view seems to have been taken, well, we can't settle with the claimants as Transform until we can be sure of a recovery from cloverleaf and Amlin. Judge rightly said that wasn't correct. There's no reason why you can't settle the main claim and look to the third-party claim in your own good time. But that was the strategy, and that was clear throughout, and one sees that in the judgment. You see it at judgment paragraph 6, for example, which is MS 198. Few lines down from the top of this is page 25, forgive me, page 25, tab 8, MS 198, 3 lines down. As late as June 2014, it refused to take part in mediation, that's cloverleaf. By then, the expert evidence showed the PIP implants had a higher propensity to rupture than other brands. Travellers wished to settle, but did not do so because it wanted to be sure of recovering against cloverleaf. The statements of Mr. Kidman and Mr. Keating both emphasised the imperative for travellers and Transform of ensuring that cloverleaf was involved so as to avoid difficulties in recovering from them later. In my judgment, there was no such imperative with respect to the insured claims, and the delay in settling those claims was unnecessary, open to travellers to settle with the claimants at any stage and to pursue cloverleaf thereafter.
But that's a settlement in relation to the insured claims.
Well, the approach taken by Transform and travellers was to adjourn ADR generally.
Yes.
And as the judge found, of course, if the reason for doing that was to be sure of recovery from cloverleaf, that can only be relevant to cases where cloverleaf might actually have insurance. And on any view, it was clear to travellers throughout, they say so, that from the outset, they believed there would be no cover from Amlin for worried well cases, because they say and assume they would have the same policy as we did. And so adjourning and putting off settling worried well cases in order to be sure of a recovery from cloverleaf would certainly assist insured cases, because they would have at least a prospect of recovery from Amlin. But it certainly wouldn't assist the worried well cases where there was never any question of recovery from Amlin. So, and this is, in my submission, this is the danger. This is what happens when you set up a joint retainer to deal with both groups of cases, and you deal with the question of giving advice about whether to settle or not, giving advice about the timing of settlement. When are we going to settle? Should we do it now? Should we do it later? The difficulty with that is that inevitably the legal advisors are advising on behalf of Transform and travellers jointly, perhaps trying to balance interests, but ultimately taking into account travellers' interests as well as Transform's. Whereas in the uninsured cases, the advice should have been wholly independent, wholly focusing on Transform's interests. And the correct advice to Transform at that point would have been, yeah, travellers had already said you can make a drop hands offer. Well, the correct advice is make the drop hands offer. There's no need for you to wait for the prospect of recovering from cloverleaf, at least in the worried well cases. That was who the drop hands offer was going to be made for. No reason at all. In fact, by waiting, what's actually happening is that the claimants are continuing to accrue common cost shares in those uninsured cases. And who's going to pay for that ultimately if the claims are successful? Well, ultimately that's going to fall to Transform with no funding from travellers. So it wouldn't be in Transform's interest to keep those claims going for no good reason. The sooner they're settled, the better, because the lower the risk of facing an exposure to adverse costs. And that's just one consequence of, and of course my learned friend says, well, we shouldn't be held responsible for the negligence of lawyers. Well, that wasn't the point. The point the judge made was that this was the consequence of having a single team of legal advisors operating on both issues. This was why the Court of Appeal, albeit with some hesitation, but ultimately said it was right that this is a relevant factor, because the joint retainer should not have been in play at this point. The proper boundaries for the joint retainer should have been for the defence of the insured cases only, albeit that would include the defence of the true generic issue, the Russian roulette issue. But on the uninsured cases, the only retainer involved should have been the single retainer. If that had happened, then the potential for identifying a conflict of interest would have been much greater. Solicitors would have been considering.
Can I just probe a little bit on that?
Yes.
Looking at paragraph 6 of the judge's judgment, the judge didn't know whether the exclusion of insurance on grounds of periods of cover applied to Cloverleaf in the same way as it did to Transform, presumably because the terms of the insurance from Hamlin weren't known. Does it follow from that you don't criticise in the same way a delay in settling the uninsured claims that were not worried well claims, because there might have been a recovery for Transform against Cloverleaf in relation to those claims?
Just to answer that question, the first point, and it's a point that the appellants make in their case. They say the judgment is riddled with factual errors, but the only example they give is in fact this point, that when the judge said here, I don't know what the scope of the Hamlin cover is, it's right that the evidence before her from Mr. Keating, or Mr. Kidman, I forget, was that by this point, Travellers did know that the extent of the Hamlin cover was a bit wider than Travellers, in that it covered a longer period.
So there were uninsured,
there
were claimants uninsured by Travellers, yes, for whom Cloverleaf may have had cover from Hamlin.
Precisely. Although, in fact, the number of cases that fell into that category was 67. And so out of the 426, obviously that includes Worried Well, but it's a small subgroup. And certainly so far as that subgroup is concerned, I absolutely accept that there would have been potentially some merit in adjourning or going along with whatever the advice would have been for the insured cases. But the judge's focus in this part of the judgment was in relation to Worried Well cases. That's the point she emphasises. And so Worried Well cases are about half the respondents, and the other half, it would be the vast majority of the other half, none of whom would have had any legitimate reason for wanting to delay settlement simply in order to try and recover from Hamlin, even if that were the right approach. As I said, the judge was right to say, well, there's no need to delay. You can settle and then pursue your Part 20 claim separately in any event. But that's
the judge said that, but do you criticise a desire to bring everybody into a common mediation as unreasonable?
On that point, my lord, lawyers didn't need to be quite so circumspect about that. And it's not so much a question of criticising the lawyers as saying that if, and this is where it's relevant to Travellers, if the retainers had been set up appropriately, and if Transform had been advised under a private retainer with Transform's interests alone, then I do say that any competent lawyer giving advice under that retainer would have said there is no, if asked, there is really no need or possible reason to delay settlement simply in order to go along with another group because they think it might be in their interest to recover from Hamlin, even if that advice is incorrect. On any view, there's no reason for the uninsured cases to go along with that. So the timing of settlement was held up because Travellers was, as the judge found, effectively holding a veto over settlement offers as much as admissions.
And those 67, we're told, went on to get settlements from Cloverleaf or Hamlin. Presumably they got their costs.
No, it was a confidential settlement agreements. I can't go into the details of it, but those claims were settled. But those
Well, they can't recover their costs twice.
Lord Malone Friends raised this question in their written case. And it's important to be clear about what that was. That this was a cause of action that vested in Transform for damages and costs against Cloverleaf. It was a separate contract and a separate legal cause of action. The administrators were able, legally, as a result of recent changes, to sell or part with that cause of action as they wished. That cause of action could have been sold to a professional litigator who had given them a percentage or paid money for it or whatever, and recovered the damages and costs in that case. As part of the discussions with Transform, it's correct that those 67 acquired that cause of action and settled it. On that point, we say that that doesn't impact upon their claim for costs against travellers. The position is different in relation to claimants who have parallel claims against Consumer Credit Act defendants. Lordship may have seen one of our footnotes that wherever a CCA defendant who was jointly liable with Transform, these are people who paid on credit cards for the damages, wherever they have recovered damages and costs, they have been excluded from this application. You may have seen that in relation, when the application was made initially, it was 426. By the time of the hand down, it was 421 because of that recovery of damages and costs from CCA defendants. So full credit is given in that respect, because that would be double recovery. So far as the Part 20 claims are concerned, because it is a separate cause of action, our position is that there is no double recovery there. However, if that is a point that Travellers wishes to make, that point can be made on assessment, because of course in principle one cannot recover the same cost twice. In my submission, it need not trouble the court with the principle of the application, because of course the principle is that they should recover their costs from Travellers in respect of their claims against Transform, which is a separate cause of action. As I say, my Lord, that is a point that could be taken on assessment. We think it's a bad point, but that is our position on it.
Why would you take it on assessment rather than on the question of liability for costs?
Okay, it could be taken on assessment. I don't say that it can't be taken now. It's not a point that has been taken until now. I'm not even sure what Malone Friends' point is. They simply ask us to explain why those 67 are included. A point has been made that they indicated in their skeleton argument below that they thought the applicants excluded those 67. We in fact clarified the position at the hearing, made it clear that it was all the uninsured cases. The only ones that were left out were those who'd settled against Transform. That position was made clear. But that is not a point that has been formally run in this appeal now, but that is our position on it, that it is a separate cause of action. The costs that they have recovered are not their costs incurred in suing Transform. The costs that they have recovered are the costs that Transform was entitled to in suing Cloverleaf. And perhaps easier to see it as an example, if this had been a professional litigator receiving the fruits of that cause of action, then it wouldn't be relevant. It just so happens that it's the claimants rather than a third party. But it's the right to that, the fruits of that, arises from the transaction between the claimants and Transform's administrator. It's that transaction that has given them the right to the fruits of that cause of action, but it is a separate cause of action. And so the judge's findings, and Malone Friends say, well, it doesn't accept on the facts, for example, that when Bevan Britton, acting for Transform, this was Bevan Britton in the coverage dispute acting for Transform, but they wrote to Hugh James and said, well, we want to make a drop hands offer, but Travellers need to consent, and their consent is not forthcoming. They say, well, Mr. Keating says that's not correct. Well, that's a conflict of evidence, and the judge was entitled ultimately to make the findings that she did, and the findings that she made were as set out. that one of the earlier submissions made by travellers at an earlier CMC. It's quoted in our skeleton argument at first instance. The page reference is 211. As it was said, it made perfect sense not to settle with Transform until we knew that our indemnity with Cloverleaf would be in place. Well, again, one can see the benefit to travellers in that, but no benefit to Transform, save for those 67. And so we do say that just as for admissions, when it comes to settlement offers, to worried well cases, in uninsured cases, that travellers had no basis at all for any interference or control in that. It's not a question of whether they overstepped the mark in terms of the Court of Appeal guidelines. They were not the liability insurer in respect of those cases. This wasn't the equivalent of a leg type case with a limit of indemnity and the need to balance interests in defending a single case. There's simply no business to be involved. Again, position might be different if one were trying to settle a true common issue as an issue, but that wasn't what was going on here. These were settling individual causes of action. And on any view, Transform were being advised, having regard to, at least in part, matters relevant to travellers, and the timing was held up, and ultimately drop hands offers were not made because consent was not forthcoming. So I turn from there to the question of insurance disclosure, and the position there had been that, of course, the judge set out and had dealt with at an earlier judgment with our insurance disclosure application, that the claimants on our side had been seeking candour right from the very beginning in the first CMC, effectively saying to defendants, or at least defendants that would otherwise appear to be unable to meet a judgment, so impecunious defendants, tell us if you haven't got insurance cover, because if you haven't, claimants have no interest in suing you to a Pyrrhic victory. Not just not in the claimant's interests, but not in the claimant lawyer's interests either, because it's going to have an impact in terms of cost recovery. So that was the position.
If
Those
they
were
didn't make
requests.
disclosure, the position was that that wasn't an implicit statement that there was general cover. It was presumably a statement to the effect that you will simply have to take the risk as to whether there is insurance cover or not, which is, after all, an absolutely routine hazard of litigation. You take the risk that you are suing somebody for damages. You may not be good for the damages or indeed the costs. You take the risk that he may or may not be insured. You take the risk that if he is insured, the insurance may be voidable or may be subject to limits which impact adversely on you. All of these are standard hazards of litigation. So that unless you're submitting that effectively there was a representation by conduct that there was insurance sufficient to cover all the claims and costs, I'm not sure where this point gets you.
Lord, deal with it in this way. Of course, I entirely accept those are the hazards of litigation. And equally, I accept that, as the judge found, there was no legal obligation on Transform to disclose insurance information. But the position was, just to step back a little bit, that Hugh James may have been the lead solicitor, but of course they were effectively informally representing a wide number of external solicitors. The schedule of respondents, in fact, one can see in the poor bundle just by glancing at the list of cases. Page reference is 155, no need to turn to it now, but one can see an array of solicitors acting for these cases. So the reason why I say that is that, of course, Hugh James, as the lead solicitor, was a stage removed from the claimants. They weren't even their own clients. An equitable approach had to be taken to avoid any kind of conflict of interest and treat all claimants fairly. And as the judge was setting out, the view had been taken, the approach had been taken. Look, if there's a defendant that doesn't have sufficient assets to meet a judgment and doesn't have insurance, fair enough, that claimant solicitor can be advised it's not appropriate to join the register. Where that's not the position, then very difficult to say you can't join the register because that might affect the lead solicitor's cost recovery, because the outside solicitor acting for the client is like, well, I'll take the risk, thanks very much. I'll take the risk of lack of insurance. So one's got to, a lead solicitor may have a commercial interest in minimising the case cohort to those that are only insured, but he also has a wider duty to all the claimants who wish to join the litigation. One's got to be very careful about shutting people out simply because it may affect the lead solicitor's position. So a lot of rhetoric in the written case from my own friend about this being all about cost recovery. But from the outset, the lead solicitor has to be careful not to exclude claimants from the register unless there's good reason for doing so. So that's the context. So the request for candour and the reason why this is relevant to travellers is because, again, the consideration as to whether to volunteer insurance, and that's the point here, not whether they were obliged to do so, but whether it was in their interest to volunteer it. That consideration and the advice given about that was, again, all given under the joint retainer. Now, my learned friend says, oh, well, it was given in Transform's interests. But the advice was being given by solicitors who were instructed jointly by travellers, paid for by travellers. And as the judge found, when you look at the reasons given for the advice not to disclose, the reasons given were reasons that reflected the interests of travellers. Don't set a precedent in respect of future litigation. They might come asking for more information. They might start asking for terms and conditions. Well, if you're an uninsured case, there aren't any terms and conditions. The answer is, we don't have cover.
That wasn't a representation, nor was it a breach of any duty owed to your clients.
No, I accept that.
Nor could the disclosure have been given, as it were, to uninsured claimants and not to insured claimants. I mean, you either gave the disclosure across the board or you didn't, surely.
But, my lord, so if one's thinking in terms of detailed information about terms and conditions, yes. But there's no reason why the uninsured cases couldn't have said to Hugh James, we don't have cover. These are uninsured. No reason at all for that. It doesn't involve generic disclosure of terms and conditions, just the answer to a question.
No, but surely the disclosure that was sought in terms of what periods are covered and are worried well, is there worried well coverage?
The application was for disclosure of information about the insurance cover because it had to be put under
Yes.
Part 18, ultimately unsuccessfully. Yeah. But the requests that had been made throughout were, tell us if you're insured. And in conjunction with that, you've got Jeremy Rauch for Transform repeatedly saying to BLM, look, wouldn't it be a good idea if we told them? Because Hugh James don't seem to understand the fact that there may not be insurance cover. It might deter them from bringing the claims.
Well, suppose it would have been a good idea. How does that advance your case? They may well have misjudged their own interest, but unless they were making a representation or acting in breach of some duty to your clients, so what?
Well, my lord, the answer to that, I accept that it's not a breach of duty in the duty of care sense, but that's not the basis for the Section 51 application. The basis, the connection with Section 51 here is, as the Court of Appeal recognised, was that this advice was being given by lawyers acting on behalf of Transform and travellers, given to Transform under the joint retainer, taking into account, and one can see that in the reasons given, travellers' interests. Now, if the arrangements had been set up properly, that is, joint retainer to defend insured cases only, separate private retainer for the uninsured cases, then one asks oneself what would have happened. Well, on the insurance request for the insured cases, travellers and Transform BLM discuss what they're going to do, make a decision. On the uninsured cases, Transform would be advised under the private retainer by BLM, funded and paid for by Transform alone, looking at Transform's interests only.
The result would have been exactly the same, which, for the reasons that my Lord Briggs gives, everybody would have known, in spite of the fact that you divide them into two camps.
My Lord, what I would submit is that competent advice, taking into account Transform's interests alone, and not taking into account travellers' interests, as in BLM in fact did when acting under the joint retainer, but competent advice for Transform alone on an independent, separately funded retainer, it is obvious in my submission that the right advice would be, yes, Mr. Rauch, your instincts are correct. Hugh James are saying, tell us if you're not covered because we have no interest in suing you if you don't have cover. You are saying to us, wouldn't it be a good idea to tell Hugh James because it might deter them? The answer to that question is yes. Tell them you're not covered. That's in line with the way in which matters were dealt with other defendants. The claims against the Harley Medical Group, which went into liquidation without insurance. They weren't pursued. And so competent advice would inevitably have been to give disclosure. Now, I accept that BLM in fact advised against giving disclosure, but the reasons for doing that, as the judge found, were reasons that ultimately were relevant to travellers. And that is the consequence, on the facts of this case, that was the consequence of setting up the joint retainer to defend all four cases. And not just all four cases, but all cases on this issue, together with one approach being taken, one set of legal advice being given, so in respect of all what was then 623 applicants, as it were, for disclosure. This is why the judge rightly found in my submission that there was a conflict of interest that was missed. The Court of Appeal agreed that there was a conflict of interest that was missed. The conflict was this, that if a solicitor acting for Transform alone properly thought through that these claims would not be brought at all or would be stopped if they were told they were uninsured, then that would mean that the common costs clock would stop for those claimants and the ongoing common costs would accrue to the remaining insured cases. That would have an adverse impact so far as travellers' potential exposure is concerned, a beneficial consequence to Transform. That is, in my submission, an obvious potential conflict of interest.
So, I mean, if I can just understand the way that it's being put, if an insurer directing the defence of a claim against his insured fails to take a point which would seriously have worried, let us suppose, have deterred the claimants, then he becomes liable for the costs that the claimant incurs, possibly from that point on or generally, on the footing that had he been deterred, he wouldn't have incurred them. Is that the essence of the submission you're making now? I understand that's not your whole case, but am I correctly summarising this part of it?
Lord, I may have misheard, but I thought George to be asking about that in the context of insured cases. In insured cases, we don't have any criticism. It's in the uninsured cases. It's not, in my submission, it's the wrong starting point.
I'm talking about the uninsured cases.
In the uninsured cases, if one were to ask the question, well, should travellers have done this, or should they be blamed for not doing that, or did they overstep the mark in doing X, Y, and Z? One is assuming that they had the right to be involved, at least to some extent, in those cases in the first place.
So your case isn't based on the proposition I put to you, but in the proposition that so far as they presumed to direct the conduct of the uninsured claims, they are effectively to be treated as a kind of intermeddler.
Indeed, my Lord. That's the point. And this is why we say that the judge was right to say that these cases are conceptually different, because it's not a question, from the Singleton cases, the Legg, Citibank, Palmer cases, because it's not a question of whether the insurer overstepped the mark and predominated in the litigation when defending a claim involving insured and uninsured elements. We're dealing with uninsured claims in which Travellers was not the insurer. And the proper threshold for their involvement, we do say, was nil. They had no business to be involved in those cases. Now, my learned friend says the Court of Appeal rejected all of this. In my submission, that goes far too far. What I think he's referring to is that when the judge said, in a separate part of her judgment, that these cases were nothing to do with Travellers, the Court of Appeal did say that she went too far. But the reason why they said that was because, of course, they're then talking about the fact that there is ultimately a common issue here. There is a common issue, and that is an issue which affects all cases. Of course, we accept that. But we don't accept that the Court of Appeal was in any way rejecting the judge's findings, judge's conclusions rather, that these were uninsured cases in which Travellers did not have the right to be involved in any way. And so it's not a question of whether they overstepped the mark on a Citibank Palmer basis, but a question of identifying as a starting point whether they should have been involved, albeit jointly with Transform, in defending those cases. The answer of my submission is no. And if that meant that interests diverged between the two groups, and that might have been on, well, would have been on the insurance disclosure point, then I do say that there's no difficulty in independent advice being taken, and if necessary, a separate solicitors firm going on the record to defend Transform in the uninsured cases. My learned friend rightly refers to this as being an ongoing dispute between the parties below and here as to whether one can have, it was said by travellers below, well, you can't have more than one firm on the record. The answer is, well, if it was one case, as travellers has falsely characterised it, that may be true. If you see this as it properly is, as a few hundred individual cases, there's no reason procedurally why one cannot have a firm on the record for one group and a separate firm for another. And that might happen in all manner of litigation. One thinks of abuse litigation because it's lots of individual causes of action spread over time with different insurers involved. Just as there were separate solicitors acting for other defendants in the litigation. Lordships may have seen in the Statement of Facts and Issues that in the early stages it was proposed that there be an alternative. There was a Worried Well case that was a case involving a claim against a different defendant, the hospital group. And then it was changed, it was substituted. But if that had been the position to trial, you would have had a defence firm on the record for one defendant dealing with that sample case, BLM on the record for others, and they would have had to work together when dealing with defending the true...
But here you're saying there could have been different solicitors on the record for the same defendant in a group of cases under a group litigation order where what the judge described in the minute of order as common issues were being tried together.
Yes.
Can you think of an occasion when that's actually happened?
Well, I don't see any difficulty with the proposition that if you had 3 sample cases against one defendant with one solicitor, a 4th sample case against another defendant with a separate solicitor, as may well have happened.
Well, I can quite see that different solicitors can instruct, different defendants can instruct different solicitors. I'm talking about the same defendant.
But it's 4 different cases, each with a separate claim form, each with a separate defence. And there's no reason procedurally why you couldn't have defence firm X defending one of those cases and defence firm Y defending another. Bearing in mind on the individual issues, they're separate. And
that would have increased the costs, would it not?
The costs would have been greater. I'm not suggesting that this was inevitable.
And those costs would not necessarily have been recoverable if the defence had been successful, not in full. A judge, I would have thought, would be likely to take the view that you can't simply multiply the costs of litigation on the backs of defendants by multiplying solicitors dealing with, to some extent, common issues, but to some extent issues which, however, even if not common, were very closely related. It's a very inefficient way to conduct litigation.
I agree entirely, my Lord, and if there wasn't good reason for it, of course that would be right. But what I'm submitting is that there's no reason, as I said earlier, that there's no reason why BLM couldn't have been on the record in the uninsured cases under the private retainer and on the record in the insured cases. It's only if there was an unavoidable conflict of interest that would arise, only in that situation, BLM would have been unable to act. In my submission, that ought to be a proposition that is not troubling to the court. Because if that isn't the position, how else do you involve a conflict of interest? Travellers' position appears to have been, well, we give neutral advice, or we try and take into account both clients' interests, or we leave the room, or we try not to get too involved. But ultimately, if you have a client defending one group of cases, same client defending a separate group, those interests differ from the travellers' interests, then you have to deal with that conflict of interest. And in my submission, that can properly be dealt with by ensuring that independent advice is taken, and if necessary, as a last resort, a separate firm going on the record. One would hope that it wouldn't come to that. And in the context of insurance disclosure, may well not have come to that. But if matters could have been dealt with sensibly, with the uninsured cases disclosing that they don't have cover, the insured cases taking whatever view they wanted to take. So there's only a last resort option. My submission, it is an inevitable last resort when you do have a conflict of interest between two groups of clients. So the Court of Appeal was right in my submission to say the advice given on insurance disclosure, the consequences of that advice, and the non-disclosure of insurance is a relevant matter on Section 51 because of the judge's findings that advice was given taking into account travellers' interests, but more importantly, given under the joint retainer. That's, in the end, ask oneself the question, how does an insurer interfere in and control litigation? Well, the answer is you do it through solicitors. That's how parties operate. The vehicle within which travellers exercised its, albeit partial, control was the vehicle of the joint retainer. Now, in that vehicle, you've got travellers and you've got Transform. Leaving aside who's in the driving seat and who isn't, that would be a relevant consideration in the insured cases. But in the uninsured cases, travellers shouldn't have even been in the vehicle. This should have been a Transform-only vehicle, giving instructions to BLM. If that had happened, as I say, there's a competent advice would have led to, bearing in mind it was Mr. Rauch's instincts throughout, why don't we just tell them it'll deter them from bringing a claim? That could and should have been done. That wouldn't have involved disclosing terms and conditions, just simply confirming no insurance.
And what do you say about the judge telling us that the claimant's advisors inferred that Transform were insured in respect of all the claims because of the judge's decision not to amend the case management directions?
Yes.
In the light of the information that she had been provided with?
Yes. Lord, that is one of the new points taken by my learned friend, at least partially a new point. But there's more to this than meets the eye.
It's narrated in the judge's judgment.
It's stated as a fact that was not the position. I think my learned friend takes a new point and goes further and says this is a sort of new point that breaks the chain of causation, and it's such an unwarranted and unjustified conclusion that it breaks the chain of causation. The position is that the judge had made an order that Transform disclose a witness statement to the judge confirming its ability to pay, whether it had insurance sufficient to pay for its own costs of defending the claims and including adverse interim costs orders up to but not including the final judgment in the case. That there was then discussion about that at the hand down because it wasn't clear what she meant by the trial. Judge confirmed it was the final judgment for damages. So the statement was intended to include, do you have insurance cover for your own costs and adverse interim costs cover, including any adverse costs payable following the preliminary issue trial? And the judge did not bring the matter back for directions because she was satisfied by that statement. But the unfortunate reality, it is unfortunate, and I accept it's not in bad faith, but the unfortunate reality is that was misunderstood. Transform understood that to mean own costs only and any ancillary interim costs orders in the like of case management conferences, but not including the trial. That was the subject of some discussion at least 2 case management conferences in 2014, when the judge made an updated order in December 2014, was then made explicit. The updated statement needs to include adverse cost order for the preliminary issue trial. And the statement that was then put in by Thorsten Sprank deals with that point. By then, of course, everybody knew they weren't insured. So it is unfortunate that order, but my submission is that there was nothing unwarranted about drawing that conclusion. Firstly, because as I said earlier, if Transform didn't have funds to participate in litigation other than from travellers, and if the statement was saying, as we correctly inferred, that Travellers was paying all of the defence costs of defending liability, that, as I said before lunch, that overstepped the mark. One would properly infer from that, if one's dealing with individual issues in uninsured cases, for example, that that's likely to mean that case is insured. When you add into that the proper understanding of the order, which was to include adverse costs payable of the preliminary issue trial, then that would only happen if Transform was insured. So we certainly don't accept any criticism about that being an unwarranted conclusion. That's by no means a certainty. One has to draw such inferences as one can. That was the outcome of the application and the reason for that inference.
Well, yeah. Well, I'm just wondering, if you're making a great deal of the way the matter was conducted by the lawyers acting for Transform, the judge narrates in paragraph 8 of her judgment what she said in her earlier judgment, that she had the power to order Transform to provide to the court a witness statement setting out whether Transform has insurance adequate to fund its participation in this litigation. And so she was making such an order. And then at paragraph 10, with the statement provided, the claimant's advisors inferred correctly that I was satisfied that Transform had confirmed they had insurance adequate to fund its participation. The claimant's advisors also inferred that Transform were insured in respect of all the claims they faced. That wasn't correct. And from what the judge tells us, it seems there was no particular reason for that inference to be drawn.
Well, she doesn't. She neither criticises it nor praises it. But the reality was that the order that was made explicitly said it's to fund your participation in the litigation in terms of your own costs and adverse interim costs up to the trial. As I say, that led to some ambiguity, hence the discussion at the hand-down, which I appreciate is not before the court.
Yes.
But the clarification was, no, it's the final trial for damages, i.e. the adverse costs bit of it includes the preliminary issue trial.
But those wouldn't be interim orders.
Well, they would be interim in the sense that they're preliminary issues in that individual case. And that was the essence of that discussion at the hand-down. The judge said it's implicit. And unfortunately, because it wasn't made explicit, there was then a misunderstanding about that. But if one wants to look for, one can see that in the December order, when the matter came for an updated statement, in the light of that confusion, the judge then made it explicit. No, it needs to include the adverse costs payable at the preliminary issue trial. The point being, of course, the judge was saying, the extent of my jurisdiction in terms of case management is that the court has no interest in managing a case ultimately. If it's a Pyrrhic victory and that affects on the claimants, that's their problem. But so far as the court resources are concerned, we don't want to be wasting court resources on managing a case that isn't going anywhere. So that would include everything up to, but not including, the final judgment in the case. That was the essence of the debate. As I accepted, I think it was one of the CMCs my own friends may even have attended, I accepted in 2014 that was something that was not in bad faith, but that was simply misunderstood by Transform, but then put right in the later statement. So it's an unfortunate set of facts that led to that inference being drawn when in fact it was not the correct inference. And the judge found at paragraph 12, so that was on that page, quite satisfied. Had the claimant's advisors known there was no insurance cover, none of them would have been pursued. This would have been entirely consistent with the approach taken to other uninsured cases. Malone and friends in their written case say that is open to significant doubt. Well, I can't deal with that fully. She had all of the witness statements available to her that lay behind the 2013 insurance disclosure application, which set out the whole history of the matter and the representations we've made at previous CMCs, and it would be improper in my submission to go beyond that finding. And indeed, it was based on witness statement from Mr. Harvey that is before this court, his 31st witness statement saying exactly that. We wouldn't have pursued them. And consistent with the other approach taken to other defendants. And so if this were a debate about marginal overstepping of the mark in an insured case, then some of these points might be said to be not sufficiently substantive to pass the Citibank type threshold in terms of being the real party to the litigation. And I accept that. Which is why I accept that in the insured cases we make no criticism. But when one's looking at these properly understood as uninsured cases, as the judge recognised, then one can see that Travellers, if Travellers is saying, as they have said in their grounds of appeal, there must be something more than mere funding of a defence. There has to be something that we did wrong, essentially. There has to be something where we overstepped the mark. Well, and they asked the question, how could an insurer avoid liability? The answer is, in my submission, a straightforward one. Insofar as this part of the submission is concerned, I'll come on to windfall in a moment, the answer is, if it's an uninsured case, don't jointly instruct solicitors, don't play any part in jointly conducting the defence of those cases, whether that's on the individual issues arising in those cases, or whether it's on tactical decisions as to whether to say to the claimants we're not insured, or whether it's on the timing or content of settlement offers, or indeed whether it's on whether to admit liability. None of those matters are matters that the insurer should have any involvement at all. And so, to some extent, it's a sui generis type case. It's not a question of, is this court being asked to go beyond the Citibank type guidelines? No. The judge rightly found their starting point is actually these were separate uninsured cases. And there may not be much of a precedent for this case, because in my submission, travellers overstepped the mark. In an uninsured case, and you shouldn't be involved. And so the jurisdiction is wide enough to deal with the most unusual facts in this case. Of course, the conflict of interest itself is then, and the consequences of non-disclosure is set out at paragraph 21 in the judgment, page 29, and the judge sketches out some figures, and I appreciate that these figures are concerned with common costs rather than total costs, so far as the windfall is concerned. And this goes to the essence of the conflict, of course, by not disclosing insurance and keeping those claimants in the group. Ultimately, Travellers becomes liable to pay out 25 or 20%, I think, of the common costs, rather than full percentage for the whole cohort, and that's a saving of some £4 million. Travellers didn't consider that matter at the time, but solicitors properly acting in the private retainer, looking at Transform's interests alone, would ultimately have recognised that that is a potential conflict. It may have been one that Travellers said, matter of public policy, or not public policy, but Travellers' policy, we're not concerned about that, it's not an issue, in which case Transform would be free to disclose lack of insurance. A conflict comes and goes, no need for a new firm to go on the record. If that may well have been the case. Travellers says, well, didn't cross our minds, it's not within our ethics, as it were, to take these matters into account. Fair enough. Transform takes independent advice. Travellers says you can disclose, they disclose, everyone moves on, BLM stays on the record in both groups of cases. So that is the relevance then of the insurance disclosure. Just brief points on Travellers' response to that. They say, well, the advice was obtained independently of Travellers. No, it was joint retainer, jointly instructed, and they say that the advice in any event was not flawed because the application failed. That's not the point. The point was that it ought to have been in Transform's interest to volunteer the information, which was essentially what they wanted to do. In terms of causation, just briefly in relation to those three broad topics, admission, settlement offers, and disclosure, of course I accept there's a different answer for each one, depending on the timings. On the admissions, insofar as an admission was requested, the focus in the judgment is in the summer of 2015. In fact, it goes back a few months before then, but an admission in 2015 would have stopped the clock at that point. In fact, the clock went on ticking until the first quarter of 2016, when default.
At what stage were the claims of the insured claimants settled?
July 2015.
Right.
And so that stopped the clock for them at that point.
Yes. The judge found that the proposal to drop hands was made in January 2015.
Yes.
And the negotiations appear to have occurred then in February, or thereabouts. So at the stage when, according to the judge, the proposal to drop hands was rejected, am I right in understanding that the claims of the insured claimants had not yet been settled?
Correct.
Right.
Well, my Lord, just to answer that, the Tomlin order was August. The mediation itself, I think, was in either June or July. So
mediation was
all around the same
But the
time.
negotiations about dropping hands, as I understand it, that was rejected, according to the judge, before the mediation. Or is that wrong?
Well, there were two parts. There's the mediation in August 2014, and then, in fact, to be fair, in June, July 2015, it was a joint settlement meeting rather than a mediation. At the mediation in July 2014, the judge found in paragraph 6, that was the point at which, although travellers had in principle permitted a drop hands offer in the event, because Cloverleaf didn't turn up, that didn't happen, everything gets adjourned off.
In paragraph 30, the judge is focusing on a proposal that was made in January 2015.
Yes.
And as I understand it, when that proposal was being discussed and ultimately rejected, it was rejected at a stage when the claims of the insured claimants had not yet been settled. Is that correct or not?
Lord, it's correct so far as the definitive settlement is concerned. The reason why I'm hesitating is I cannot now recall the precise dates of the joint settlement meeting where there was a negotiation in principle subject to a Tomlin order. I genuinely, but it was all around that time. I cannot be precise about that.
I mean,
maybe I can come back to it.
one of the, however many people you've got on the record advising you in relation to different claims, one of the problems that litigants habitually have to deal with is that if you settle one part of a claim or the claim of certain components before others, it may have an adverse effect on the claims that are still open. I mean, that's a piece of elementary litigation. You try and ensure that that does not happen. Now, it was surely not possible simply to look at the settlement simply in relation to the 197 insured claims. You had, as a responsible solicitor, to consider what the knock-on effect would be on your ability to resist liability or to resist an unfavourable settlement with the insured claims if you went and settled first, especially on an admission of liability, with the uninsured ones.
Well, of course, the factual reality is that the insured cases were settled in July and the uninsured cases were not. They continued until the first quarter of 2016 when judgments were obtained at that point.
Yes.
So they did settle the insured cases, but not the uninsured cases.
Right.
But I
mean, it's the other way around that's the problem, isn't it? From the traveller's point of view, they were entitled to give directions to Transform as to the way they conducted the litigation. They, I would have thought, were going to be concerned that if they settled with the uninsured people in advance of the resolution of the insured claims, that would prejudice their position. It would reduce their bargaining power in dealing with the insured claims, and it might prejudice the actual conduct of the claim. Now, it wouldn't necessarily do that, but that's surely a legitimate consideration when you're thinking how to direct a single client, a single insured, as to how she should conduct litigation. Are you not entitled to say, do not conduct litigation, quo-ad uninsured claims in a way that prejudices or may prejudice the conduct of the claims of insured litigants?
Well, two parts of that answer. The first part is that so far as the uninsured cases are concerned, travellers had no right to give any directions at all in respect of that cable.
I think that misses the practical point. They were entitled to give directions to Transform, quo-ad the insured claims. Now, are you submitting that they were not entitled to say, this is a single piece of litigation which involves insured and uninsured claims, you may not conduct it as regards the uninsured claims in a way that prejudices the insured claims. So, for example, if an insurer would be entitled to say, I do not want you to admit liability to all of these other people, because that would be a way of conducting not just the claims of the uninsured, but the claims of the insured ones as well. The two things would have a relationship to each other. Is that not a position that they were entitled to take?
Lord, no. I do say they were not entitled to take that position.
Do you have any authority for that proposition?
Well, Lord, the principle is this, that their contractual rights and obligations were in respect of insured cases.
That I do understand, but the factual position that they were in was such that they were not in a position to make the neat distinctions that your submissions imply. That's just a purely practical point. It may not be possible to conduct the defence of insured claims simply in isolation from the fact that the very same litigation involves some 400 uninsured claims.
Well, I said it was in two parts. The first point, I don't accept they had the right to do so, but the second part is that there would be no prejudice to travellers in the uninsured cases settling on a drop-hands basis. In my submission, that doesn't arise. We're dealing with a judge being told, my lady, there are 400 cases, Transformers agreed, drop-hands terms, they're uninsured, Transform has no assets, there's no prospect of a judgment, they've agreed terms in those cases. In the insured cases, because by this point it's clear which are insured and which are not, in the insured cases, they will continue to trial. That would be no different from dealing with it in respect of any other defendant. And the reality is that would not and could not prejudice the merits of Transform's substantive defence in the insured cases. What would we have said as claimants at trial? We would have said, well, you have settled some other cases, to which the judge says, well, I'm not concerned with those cases, I'm concerned with these cases. So in my submission, there is no... The suggestion from my learned friends that these are all prejudicial and you can't deal with one without the other derives from the root error of seeing this as a single claim and a trial of a single common issue, and you're admitting that issue or settling that issue. In my submission, that's not the reality here. Separate causes of action. If you choose to settle one cohort, either because on their individual merits that explants have been examined and found to be substandard, or for commercial reasons, as would be the case in the uninsured cases, there's no knock-on effect in respect of defending the other cases at all. But in any event, even if it was thought that there would be, the way in which that would work, in my submission, is that the solicitor acting for Transform and BLM on the private retainer would consider, is there a conflict of interest here? It would be dealt with by resolving that conflict of interest. But so far as travellers is concerned, I do say that they had no business to be involved in playing any part in settlement of those cases, any more than another defendant would have done. The distinction between travellers and another defendant is that travellers are paying for the defence of the generic common issue. But that's really the only distinction. And settlement of an uninsured cohort does not, either necessarily or in practice, impact upon the merits of defending the Russian roulette argument, unless that issue itself were to be admitted, and that's not what was being sought.
Can I just check this? I think I've understood that the insurance cover position was fully revealed by June 2014. So that at that point, if the uninsured claimants continued, it can only have been on the basis either of avoiding a cost liability upon a discontinuance, or because they wanted to get costs in the way they ultimately did get under Section 51, by going all the way to a summary judgment and then getting a non-party costs order. Because the logic of the judge's conclusion that once they knew they were uninsured they wouldn't have sued requires some explanation for taking the different course that we know was taken once the position was fully revealed.
But Lord, absolutely.
Now, it follows, doesn't it, that by the time we get to 2015, when we're talking about admissions and drop hands and so forth, we're into a scenario where the uninsured claimants are seeking to go ahead to get a cost recovery under Section 51.
Lord, yes, certainly. There are only a limited number of ways out of
Yes.
the ongoing common cost recovery: discontinuance, settlement, admission or judgment. Those, in practice, are the three mechanisms. Applying to come out of the GLO register is quite difficult because it involves conflict of interest, because the remaining claimants then have an additional costs on their shoulders.
But the evidence shows, I think, doesn't it, that Transform were asking whether travellers would consent to a drop hands settlement. But did the drop hands initiative come from the uninsured claimants, or did it come from Transform?
It came from it was Transform's correspondence.
Does the evidence show that the uninsured claimants would have accepted a drop hands at that stage, or were they going all out for a costs recovery?
There's no evidence on that, my lord, not least because, of course, Bevan Britton, who wrote the letter, was saying, we'd like to, in principle, make this offer, but
yes, but it never got made.
Losing our consent. So it's a hypothetical question.
So how does the causation argument run that any costs would have been, any of the uninsured claimants' costs would have been saved by the making of such an offer?
Lord, I accept that evidentially it is a matter necessarily of uncertainty as to whether that offer would have been accepted.
Yes.
But the uninsured cases needed to get out of the litigation. Now, settlement, as it happens, wasn't proposed. But once it was clear that Travellers was not interested in continuing to be involved in the uninsured cases, there was no funding at all. At that January 2016 CMC, there was a very rapid progression to default judgment.
Yes.
So that was the quickest route to get out, was to default judgment. And of course, it's right that that is of assistance in making the Section 51 application, which was already by then in prospect. So I don't in any way shrink from that. Judgment is a necessary step for getting the Section 51 judgment. Learned friends say, well, that's all exercising fees generation. Well, the answer is no. These were claimants who, if they hadn't got judgment, in the absence of a settlement, the only way out is to discontinue. You're paying adverse costs. Your ATE insurers are exposed to that bill, and you're not recovering any of your own costs, including disbursements, whether for your own lawyer up and down the country or Hugh James as a lead solicitor. It's certainly not in your interest to discontinue. If the criticism is, well, you could have dealt with this in some other way, reopened settlement discussions, but you chose to get judgment as a stepping stone to get a Section 51 order, well, it's in the claimant's interest to recover their costs. And if that's recovered by a mechanism of Section 51, well, that recovers their costs. Their insurers are not paying out, their disbursements are covered. So I don't make any apology for the fact that a judgment is a necessary stepping stone for Section 51. But as it happens, it's also the most convenient and expeditious route to stop the clock. It's the only practical way to do it, short of discontinuance. May I just check one problem? On
what I found quite different with this case, I got no feel for the rate of costs accrual on the claimant's side when the big money was incurred. I'm assuming an awful lot was incurred up until the deployment of the expert evidence, which caused, according to the judge, a sea change in everybody's perception of the merits. And that was before the first mediation in 2014, wasn't it?
Yes. Well, I suspect that would be fair. I don't have the figures to hand. It is worth mentioning, though, of course, and keeping in mind that Transform wasn't the only defendant, and so there were other defendants still in the litigation, solvent and fighting, up throughout until summary judgment was obtained in the spring of 2016. But I accept that so far as the expert evidence work is concerned, that was substantially at an earlier stage. But I can't go further than that without figures at my fingertips. The common costs, of course, weren't just about evidence. It was also the ongoing management of the litigation, the CMCs, and the ongoing processes, which were inevitably time-consuming when dealing with multiple defendants, and everybody's paying a share of all of that. So you've got CCA defendants and activity going on there. You've got other solvent defendants still in the game. I think there were, I forget now, but there was certainly a handful of defendants, active solvent defendants, still in the litigation in that first quarter of 2016. So, but I can't go any further than that. So on causation, on admissions, yes, that's 2015. On settlement offers, yes, it's at a later period during the timeline. On the insurance disclosure, of course, the requests for candour go right back to the very beginning. And if the retainers had been set up properly by travellers, and as the judge found, that would have led, but for travellers' interests, as she said, which wouldn't be in play with a private retainer, the insurance would have been disclosed, the claimants wouldn't have pursued their cases. Causation is established in full from the outset in respect of that topic. I accept that causation is an important factor. I would submit that it doesn't have to be slavishly followed on a but-for basis for each and every criterion. It's part of the broad discretion. In fact, as said in Dimmock's, the insurer would not ordinarily be liable in the absence of causation. But I must move on, or I will have limited time for the reciprocity point. Can I turn to that, Lord, and as quick as I can? So this is a point, of course, which is linked to the trespassing beyond the proper control, because it's linked to the joint retainer and the conflict of interest. But it's also a matter that stands on its own merits. It's not, the position is not, well, the reciprocity means that the insurer, because they would have recovered their costs, albeit partly by subrogation, but still recovered their costs, means they have to pay out. That would indeed open the floodgates. It's certainly not the case that just because there's a recovery on one side, it means there should be reciprocity on the other. The windfall that arose here was as a result of a very specific set of two sets of circumstances. One is the fact that there were a lot of uninsured cases in the cohort, which is happenstance. I think, as Lord Sumption said, that can happen, and it's unsurprising that might happen. I accept that. But the second ingredient in this particular idiosyncratic set of facts is that this was group litigation involving cost sharing, several cost sharing, because had it not been for the several cost sharing machinery of the GLO, if this had been a pre-GLO matter, a common law matter if you like, then the costs incurred by the sample cases would have been incurred by them alone. All the other cases stayed. Those costs would have included their individual issues. They also would have included their costs of running the generic issue. And there would be joint and several liability for those generic issue costs, which perfectly matches the position as regards Travellers and Transform. And so following a successful outcome, the two insured sample cases would have recovered their costs in full, and that would have included all of the costs of the true generic issue, except the two uninsured cases would not have recovered their individual issue costs. But so far as common cost is concerned, essentially those costs would have been paid indirectly by Travellers to the claimants, to the sample cases. That's the position at common law, and that is the position which, in my submission, one can properly say Travellers bargained for, in the sense that the premium paid, the premium received, was there to deal with a possible situation in which they may have to pay out claimants' costs in circumstances where either all the claimants are insured, that's one possibility, or if it's not a GLO, there's no several cost sharing, and even if they are a mix of cases, you still be paying out in full. Remember that GLOs are not a mandatory tool for case management, and there's no reason in principle why the court couldn't have said, well, actually, these are sample cases, there's a mix of individual issues here, we can deal with this in a coordinated way with some cases going to trial, stay the other cases. And so from a commercial point of view, it would have been entirely unsurprising and within their reserve for Travellers to have found themselves exposed to paying all of the claimants' common costs. And that would always have been the case, absent several cost sharing.
The reason why they wouldn't, on Mr. Middleman's argument, is that you're only liable for the costs you've actually incurred, and the costs that each of these claimants has incurred is a several liability of his own, and most of them were uninsured. Surely the reason why there is no equivalence between the right to recover costs upon a successful defence and the obligation to pay the costs on an unsuccessful defence is that the former is purely procedural, as far as travellers is concerned, whereas the latter is contractual under a contract that has certain limitations to the benefit of which travellers are entitled.
Lord, I entirely accept that is the consequence. You throw the dice, and the happenstance of litigation arises that there is several cost sharing.
It's not happenstance. It's the limitations deliberately inserted in their contract.
Yes, but the fact that you only pay what turns out to be a proportion of the common costs is because of the happenstance of A, several cost sharing, and B, a mix of insured and uninsured claims.
Well, and C, an insolvent defendant.
And an insolvent defendant.
Which, if you like, gives rise to the risk of lack of reciprocity anyway.
Yes.
Because a liquidator always recovers in full if the insolvent defendant wins.
Indeed.
But also, is there not a sort of rough with the smooth aspect of several only cost liability? As I understand it, the thinking behind several only cost liability is both that it doesn't leave test claimants exposed, but also it doesn't leave any individual claimant with a deep pocket exposed disproportionately. Everybody takes an even but several only share. But if the rough side of that coin is that in a situation where half of them turn out to be suing an insolvent defendant who hasn't got any insurance, why is not that lack of reciprocity also, if you like, just a consequence, a side effect of taking the benefits of a litigation regime which gives you the protections of several only liability?
Well, my Lord, of course I accept that's the origin of several cost sharing, is to create that level playing field between claimants to avoid some bearing a disproportionate burden of the costs. Although in practical terms, in a world of conditional fee agreements and so on, it's not quite the same as a full private liability. But I accept that is part of the reasoning behind it. But the essence of it is to create a level playing field to ensure that there is a just outcome. On the particular facts of this case, of course, it wouldn't always be the case. One would make an order based purely on a windfall. On the particular facts of this case, the outcome has been that, unlike the common law position, where only the lead cases would have incurred their costs and, in fact, would have recovered them, so long as there's at least one insured case in that cohort of lead cases, they would recover, in effect, the full common cost liability. So to pursue your Lordship's example, it would have to be a situation where all 4 sample cases were against an impecunious, uninsured defendant. But that wasn't the facts of this case. Once you've got one insured case, you get your recovery in full if it's joint and several. Whereas those costs have in fact been shifted onto the shoulders of claimants who are unable to recover them, but who are left facing a cost attributable to somebody else's case and not their own. Now, what I say legally about that is that the aid and shipping dicta, this is a broad, wide discretion, is entirely able to encompass an idiosyncratic outcome such as this, with the caveat being what was referred to as the 2 provisos in aid and shipping in the Eli Lilly Court of Appeal judgment. First, that there's no procedural rule saying you can't do it, and the second is that it's a proper exercise of judicial discretion. This is a wide jurisdiction, a wide discretion. It's not the appellant's case that they're inviting this court to depart from aid and shipping, and I take that legally as the starting point, that is the position. And if there is a wide discretion, there's no reason why a court would be acting impermissibly in saying, in all the circumstances of this case, including Travellers' conduct in defending the uninsured cases, say what one wants to say about how far they overstep the mark, but on any view there is an overstepping of the mark, because there shouldn't have been funding and jointly controlling the defence of the uninsured cases. But taking all of those matters into account, and then looking at the windfall that resulted, which, depending on your finding as to causation, may have been wholly or partly attributable to the use of the joint retainer when it shouldn't have been, and the missing of the conflict of interest by lawyers who ultimately were the agents of Travellers as much as Transform, because they were jointly instructed. You put all of those circumstances together, and one asks, is it permissible to make an order that levels the playing field and restores to Travellers an exposure which they did bargain for? I accept my learned friend's point that if it's purely about the windfall and there's nothing else involving a criticism of Travellers, then it's strictly correct that correcting the windfall would be to limit the order to common costs only. But one needs to look at the case as a whole and look at all of the circumstances. This is Travellers ask, well, what this would be opening the floodgates to all sorts of cases, including non-group litigation. Well, it wouldn't arise without a GLO, without several cost sharing. This position simply wouldn't have arisen. It only arises as a result of those particular features. And ultimately, in considering discretion, the question is whether she was permitted to exercise it on the particular facts of this case. This is a judge who'd presided over the case for several years. She presided over a large number of CMCs, actually dealt with insurance applications. She was in a proper position to get a full measure of the extent to which Travellers had in fact involved themselves in the defence of these cases. I'll just take instructions on one moment. In that case, just in the limited time remaining, my Lord, just to go back to the aid in shipping dicta then on this. At tab 2 of the primary authorities bundle, at MS page 1035, just to draw attention really to F to G. In these circumstances, it's not surprising to find the jurisdiction conferred under Section 51, like its predecessors, to be expressed in wide terms. The court shall have full power to determine by whom the cost should be paid. Such a provision is consistent with the policy under which jurisdiction to exercise the relevant discretionary power is expressed in wide terms, thus ensuring the court has, so far as possible, freedom of action, leaving it to the rule-making authority to control the exercise if it thinks right to do so in the appellate courts. And so to allow this...
Those last, where you just broke off is quite important. And the appellate courts to establish principles upon which the discretionary power may be exercised.
Yes, my Lord, indeed. And I don't in any way ask this court to overturn any of those principles. There are nuances between us, best left for the written case, in which we would say that the Court of Appeal guidelines are not rigid criteria that must be established. We would say they're guidelines and should be the servant of reason and justice and not the master, as the Court of Appeal has said in other cases. But in essential terms, we entirely accept parties and insurers need to know where they stand. Those guidelines are entirely appropriate guidelines for governing how you defend or be involved in the defence of an insured case. What I do say is that they have no application when dealing with how you defend a group of uninsured cases. And on that, which is really a sort of sui generis category, the Court of Appeal has said in Symphony, for example, the categories are not closed. This is a category in its own right. And if where there is a right to have joint control, the threshold is have your interests predominated over the insured, or have you acted exclusively or predominantly in your own interests? If that's a threshold that applies where it is an insured case, then the question that arises for this court is what is the threshold in a case that is not insured? Leaving aside defence of the true common issue for the moment, because I accept, as the Court of Appeal said, it goes too far for the judge to say that's nothing to do with Travellers. Just put that to one side, because the criticisms that the judge made and the criticisms that I make are not to do with the defence of the true common issue. They're to do with all the other bits. On those aspects, I do say that there's nothing in any way inconsistent with the guidelines to date, that the proper threshold is nil. Acting beyond that threshold opens the door to the court's jurisdiction, provided that what he's done is just. And when one then takes into account the windfall aspect of the case, this was a just decision. And in future cases, if insurers will know where they stand when it comes to an uninsured claim, don't get involved. Leaving aside sample cases for trial, certainly don't need to get involved in whether or not there's an admission of liability, whether or not there's a settlement offer, and whether or not to disclose the insured to disclose the lack of insurance. This is an insured in relation to a separate group of claims for which there's no insurance. If one is to allow the appeal, then one is effectively to say, despite that wide jurisdiction the House of Lords has recognised, enabling the court to do anything that is just, that it prohibits the judge in this case, despite finding the findings of fact that she made, and bearing in mind on the permission to appeal application, she confirmed, even if I do have to apply the Citibank type test, my answer would inevitably have been the same, to use her words, given the facts that she found. So where you do have a trespassing beyond that threshold, interfering in those issues, and a windfall consequence, that is precisely the sort of case that properly falls within the width of that discretion. And I perhaps conclude by reminding what once again, as we did in the Court of Appeal, there's actually Travellers' submission when they'd made an application for Section 51 costs against Amlin at one stage, after the Part 20 claims had been dismissed, so they hadn't even achieved success. They applied for costs against Amlin. It was my learned friend's predecessor, Mr. Phillips's submission, as the judge has set out in her judgment, that the discretion is as wide as it can be and entitles the court to do anything that is just. Bit of a jury point, but that was their submission. But in my submission, it is the correct analysis. And insurers, if this appeal is dismissed, as I invite it to be, insurers will go away with the message that when it comes to uninsured cases, keep out. When it comes to correcting a windfall, look, there are going to be situations where it will ultimately be just to restore to us that which we have bargained for, rather than allowing us to retain a windfall at the expense of uninsured cases. And in the end, the principle is not, would this court have made a different decision, or can one be satisfied that the judge was right, but was the judge wrong? Was she acting outside that broad scope of her jurisdiction? And of course, she wasn't just any judge, she was the managing judge who dealt with this for many years and was well placed to make these orders. And in my submission, it is important that that discretion for a first instance trial judge is preserved, and this is in no way stepping out of line with the Court of Appeal authorities. Just take instruction. Nothing further.
Thank you very much, Mr. Porter. Mr. Purderstorfer, do you follow? Mr. Edelman.
My Lord, the only substantive legal submission that the learned friend has made in the course of his submissions is in relation to aid and shipping. I'll just spend a few minutes dealing with that, because with respect to my learned friend, our submission is that he's misunderstood what's being said in that case. All that is being said is that Parliament necessarily expresses itself when granting discretionary powers to the courts in wide terms, so as not to constrain the courts as to how the courts go about exercising that discretion. That is left to those who draft the rules of court and to the appellate courts to set their own guidelines and rules as to how the discretion is exercised. And it arose in that case because the submission in aid and shipping was that there was an implicit limitation in the statute that constrained the court from making a Section 51 order against anyone other than a party to some piece of litigation before the court. Could be two conjoined pieces of litigation. But when the court rejected that submission, they did so on the basis that there is no such limitation in the statute it is expressed in broad terms to give the courts the discretion to exercise in accordance with its own rules and appellate guidance, which the court then did by saying it's not so limited. And of course, that was the point of Mr. Phillips's submission about the breadth of the jurisdiction, because he was trying to say that a potential candidate for a Section 51 order is the insurer of a Part 20 defendant, even more remote from the original claimants. And so he was saying that the target of your order can be as wide as can be, and that is consistent with Aden, but doesn't suggest that the criteria for making a Section 51 order should simply be, I think it used to be described the length of the Lord Chancellor's foot. Now, the only other authority learned friend referred to was Wyeth, and just if I can say a word about that, it's at the Authorities Bundle 2 at page 1736. Tab 40. Page open. I just wanted to, learned friends quoted from that case about the costs, defence costs, and I just want to refer you to, my lords, my lady, to paragraph 56 on that page, because in that case, Lord Justice Dyson's, sorry, it's not Lord Justice Dyson, Lord Justice Waller says, it seems to me that if the starting point is that the costs do reasonably relate to the defence of the claims falling within the policy period, the contractual right of Wyeth is to be paid those costs. I do not see, once that threshold has been reached, that there is any room for saying that simply because the costs may also relate to an increase in the injury during some period outside the cover, the obligation on Cigna is cut down in some way. That is the view that the judge took. It's supported by the New Zealand product case. And this aspect of reasonably related to the defence of the claims falling within the scope of cover is particularly apposite in this case, because what the learned friend has attempted to do is to salami slice what were common issues to try and suggest that there were aspects that were not common issues. But it overlooks the entire point of the GLO, which was to deal with common issues of fact and law in the same piece of litigation. And the whole point of having sample cases, which is in an attempt to reach a conclusion which will be relevant to all of the cases by reference to sample facts, the sample facts of sample cases. And that is necessarily because, not just because of this, what learned friend describes as the Russian roulette argument, but also, particularly because all these cases were against Transform, that it is reasonably to expect, and this was put to learned friend in the course of his submissions, and in my submission it's right, that it is to be expected that the employees of the same company would be giving similar warnings or making similar representations over the years to the same claimants. There may be difference in particular language, but the idea of sample claims is, well, if they said something like that, that has particular legal consequences, or it has no legal consequences. And the idea is that if you try it on the facts of that case, that will give you the answer to all the other cases in which either the same or something similar was said. And that's the entire point. And to start suggesting that this somehow leads to a separation of the uninsured cases into a world of their own, where travellers is not allowed to tread, is, we say, simply unreal. And that was, the learned friend spent quite a bit of time in the early part of his submissions trying to establish that, and it did seem to be the entire foundation of his submissions, that there was some severable element of this in which travellers did not have an interest, whereas the reality was it was all, to use the words from Wyeth, reasonably related to the defence of the insured claims. It was inseparable, in fact. is much further than the Wyeth case. Can I just say a few words about the other aspects that Learned Friend dealt with? Firstly, of course, it is the point that the whole issue about admissions and settlement offers all come after, as far as the judge is concerned, all come after the claimants knew full well what the insurance position was. And there's, again, an air of unreality about relying on this, because if, with knowledge of the insurance position they were carrying on, it can only have been, when they knew about Transform's financial position as well, it can only have been with a view to recovering costs from travellers. In those circumstances, the suggestion that a drop hands offer would have been accepted is fanciful. It would undermine the entire object of the exercise. But in any event, particularly in the context which Learned Friend was constrained to accept was the case, with a looming prospect of a settlement of the entire cohort of claims, didn't actually happen at the settlement. In the end, only the insured claims were settled, but there was a joint settlement meeting to attempt to settle everything. That travellers or BLM should be taking the view that it was more sensible, rather than making some admission of liability in advance of that, to deal with it all together. That is, travellers, we submit, protecting its legitimate interests. I think there's only one other matter that I would like to draw to your attention, and this is on the what the judge said about the insurance, on the insurance disclosure application, and that is in Bundle 2, Appendix 2, at tab 17. I'd like to invite your attention to this. And it's page 166, the original numbering, 536 electronic. This is the judgment on the insurance disclosure application. And you can see what it is at, this is not authorities bundle, this is the appendix, this is Appendix 2. Page 166, 536 in the electronic. Paragraph 6 said, in the course of his submissions, Mr. Preston accepted that the claimants want to know whether Transform had sufficient insurance, 1, to fund its participation in the litigation to the end of the trial, 2, to meet any order for damages, 3, to meet any order for costs. And what the judge says about that at paragraph 36 is, I'm satisfied that CPR 3.12M gives me power, this is page 173, to order Transform to provide to the court a witness statement or statements setting out whether Transform has insurance adequate to fund its participation in this litigation to the completion of the trial and the conclusion of any appeal. That knowledge will permit me to case management this litigation now on the basis of adequate information.
In fact, if you look also at paragraph 35,
yes. Yes, I should
I'm
not
satisfied that I should not make any order which requires Transform to provide the answers to questions 2 and 3 of paragraph 6.
And we submit that that could not be clearer. That was the sum total. And Lord, just one final observation before I sit down. It is sometimes the case that the way in which courts manage litigation has extraneous financial implications in certain circumstances. And one of perhaps the most notorious situations in which that happened was the management of the Lloyd's litigation in the 1990s, where the court set a timetable for trials of actions. One was to be tried after the other. That led to an application in Cox and Bankside, because those claimants in the middle of the queue or at the back of the queue complained that the management of the litigation by the court meant that they were behind everybody else in collecting what limited errors and omissions insurance was available, because those who were at the front of the queue would scoop the pot first, and demanded that the court do something about it, because the court's case management powers, as exercised, had these implications. And the court quite rightly refused and said, that's tough, we have to manage the litigation, this is the way we manage it. If it has financial implications, I'm afraid that's the price you pay of case management. And sometimes, well, if we say that's always what the court must do. And if the way in which the courts manage group litigation through cost-sharing orders has, in particular circumstances, which is this, where it transpires that they're insured and uninsured claims, and the particular defendant is uninsured for some of those claims, that is, I would submit, just tough. And the court shouldn't try, as it didn't do in Cox and Bankside, shouldn't try to correct the financial implications of its own cost management decisions. Unless I can help on any specific matter my learned friend raised, I think my time is up.
Thank you very much indeed. Well, the court is very grateful to all counsel and to those sitting behind them for their involvement also in presenting us with the arguments. This is obviously a very important case. We'll take time to consider all that's been said and issue our judgment in due course.